Thank you. I'll get started for real this time. I'm talking about executors' duties, but the emphasis is on the fiduciary nature of those duties. And there's been, I think Cathy touched on some recent cases in relation to fiduciary duty on the part of solicitor executors and where they've run into trouble, and particularly in relation to disciplinary proceedings. But my paper generally addresses the main executive's duties, and all of them are fiduciary in nature. And surprise, surprise, the executor's primary duty is to administer the estate. And that's because the executor and executor has a fiduciary duty, like any trustee, to perform the task undertaken and to obey the directions of the trust. And that means taking control of assets, getting them in, ascertaining and discharging liabilities, and at the end of the day distributing the net estate to beneficiaries. And I think we people who practice in this area never cease to be amazed at the trouble that executors can get themselves into in administering estates and carrying out or failing to carry out those very basic duties. As with every fiduciary position, there's a duty of care and skill. Importantly, there's a duty not to profit from the position, to avoid conflict, and to act in good faith for the proper purposes of the trust. And there's this overriding duty, and there shouldn't be any surprise, to manage the estate for the benefit of the beneficiaries, because that's what the executor is there for, to act for the beneficiaries. So just looking at some basic duties: to dispose of the body. The executor has the right to possession of the body. There's no property in a dead body. But with that right to possession goes the duty to dispose of the body, and that includes the right to choose how to do it, whether by burial or cremation. And the law expects, but executors aren't obliged to consult with other persons interested. And the testator's wishes or any directions in the will in relation to the disposition of the body are not binding on the executor, as it's impossible to dispose of your body in your will, except for the donation of organs. And the Human Tissue Act, Part 4, addresses that, and donation of body organs are binding on the executor. So the second basic duty is to ascertain, call in and realise the assets, and that's to be done with due diligence. And if there's not due diligence, the executor can be liable for any loss occasioned by delay or failure, though they can be excused if they can show that taking action to call in an asset would have been pointless, or there was reasonable ground to believe that taking action to call it in would have been pointless. And for example, where a proceeding to call in a debt would have very little prospect of success. Now, the executors has a duty or a power to sell assets only when they're authorised to do so, and that can be authorised by the will, by statute. Section 44 of the Administration and Probate Act enables an executor to sell any part of the estate, but it's a restricted enablement. The power to sell is only for the purpose of paying debts and administration expenses. So apart from the Act and the will, there's also the ability to go to the court if you need to sell assets and get permission from the court. But if a will doesn't have a power or a option to sell property, the executor wants to sell for other purposes, he or she can't do so without the consent of the beneficiaries or the order of the court. And selling without those powers can incur personal liability. And sometimes the executor has no choice but to sell, and that's where there is a trust for sale, not an option to sell, but an imperative duty to sell. And that's where the language of the will is such that assets must be sold, and that usually comes with a power to postpone sale as well. And executors have to be very careful when postponing that power to sell in relation to later action by the beneficiaries and then incurring personal liability. And the executor is under a duty to sell assets in the manner most beneficial to the beneficiaries. And that means inviting competition and conducting themselves in a way that a prudent person would if they were managing their own affairs. And there's a duty, of course, to sell for the best price. And inviting competition usually means by auction. Then there's a duty to ascertain and discharge liabilities. There's a general duty not only to beneficiaries but also to creditors to pay the testator's debts, once again with due diligence, provided that there are assets available and properly applicable for that purpose. And if the executor fails to pay debts with due diligence, once again they can be liable to beneficiaries for any loss caused by that. And what is due diligence? Well, it may be payment within the first 12 months of the date of the death of the deceased, and that's referred to as the executor's year. But the executor can't be compelled to complete the administration or to pay estate debts within that 12 months. They may choose to, and they may choose to if it's a relatively simple estate, or there's no reason why they should not do that. But if the debts aren't paid within the year, the executor is put on the back foot and has to justify, if called upon to do so, any delay in payment. And that duty to pay or discharge liabilities with due diligence can be modified if there is a power, and there is a power in most wills to retain part of the estate for so long as the executor thinks fit without incurring any liability for loss. Another fundamental duty is the duty to invest. And once again, you'd be amazed at the number of executors who don't invest and thereby incur liability. And if they fail to invest, they can be charged the lost interest that would have been earned. The type of investment isn't prescribed anymore. It used to be under the Trustee Act, but they can invest in any kind of investment, but they do have a duty of care, and that's different for a professional executor and for a lay executor. And I've set out in the paper in paragraph 9 the different standards of care. And there's also a duty to review the performance of trust investments at least once a year. The will, when I said invest in any kind of investment, that's of course subject to the terms of the will. The will may prescribe, and some wills do, what the executor can and can't invest in. But otherwise, the will will come under the Trustee Act, and the executor can invest in any form of investment, but there's still duties under the Trustee Act and under the common law to invest in the best interests of the beneficiaries, not to invest in speculative investments, to act impartially towards beneficiaries, and to take investment advice. And there's a paramount duty to minimise risk by diversifying trust investments, and once again personal liability has been incurred by executors for failing to do that.